I don't think I'm live yet. Okay. YouTube, man, you guys are killing me over at YouTube. I click the button to go live and delay and delay and delay. I'm like, okay, come on, guys. And here we go. All right. Welcome back, everybody. YouTube live presentation number 14 out of 20. We're in a groove. We're on the home stretch. We've shared a lot of information, a lot of good stuff in the live chat. Over 3,200 viewers of our 13 YouTube live presentations so far. So the one today is about how to protect your estate from lawsuits. Going to do a little bit of housekeeping and then we'll jump in. Thought I'd share with you a little insight today that I haven't shared with you before. Some of you may be saying, Paul, how do you just go for 30 or 50 minutes just off the cuff? And, some of you might be saying that. Many of you probably aren't. But in case you're wondering, how I get my material, how I organize my material, I'm in my house on my dining room table, and I actually have a teleprompter, and I'm going to show you my state-of-the-art teleprompter. Let's call it the COVID teleprompter. And here it is. It is a spray thing of Windex with my notes taped to it, propped up on a box. So there you have it. There's my secret technology. That's my little secret weapon that I use to make sure I stay on track. So congratulations for that, for what it's worth. Couple of questions. I was reading Hannah's, who 22 hours ago wrote on a comment. Tough situation for Hannah. Says, thank you, very informative. Unfortunately, as an executrix, I'm going through hell with probate. Question. My brother was the beneficiary of an IRA and passed away 11 months after the death of our mother. I am not able to access that now, just was able to get the order from court as an executrix. Also, he was under state care, Title 19. How do you deal with that situation? Help. Okay, Hannah. So as I read that, I'm assuming, and I think I'm right, that you are the executor or executrix of your mother's estate, and you started probably working with a lawyer. Paperwork got filed at the courthouse, and a judge signed an order confirming that you are the, I'm going to call it executor, you could say executrix. I'm going to use the kind of gender neutral executor. Judge signed an order that you're the executor of your mother's estate. And then lo and behold, 11 months after your mother dies, your brother dies. And kind of as a side note, your mother had an IRA of which your brother was the beneficiary, but he died. So normally beneficiaries, they go to the financial institution where they're named a beneficiary, and they work with that financial institution to move their part of mom's IRA into a inherited IRA or beneficiary IRA, whatever you want to call it. But he died. He's not able to do that. So what's going to have to happen in that circumstance is someone, I'm assuming your brother did not have a will, then someone will have to petition the appropriate court in the state where your brother lived to be appointed as the administrator of your brother's estate. And then that court-appointed administrator can go to your mother's financial institution and apply for that portion of your mother's IRA proceeds that would be payable to your brother's estate. And that court-appointed administrator can do that. Those funds would go into his estate. And then again, state law would determine who would be entitled to all of that. There's going to be some significant income tax consequences to all of that. So hope that helps, but that's the best answer I can give based on the question that you asked. Okay, jumping right in to this is a topic. It usually rears its ugly head too late. Too late meaning something happened, and now the person that allegedly caused something to happen wants to take action to try to protect whatever they have, whether that's a home or rental property or a business or money in the bank or retirement accounts. And so all too often that conversation is had too late. I'm not going to go into the details, but once something happens, it's really you pick the word, anywhere from inappropriate to illegal to move your assets around in an attempt to kind of hide them from potential creditors. So that's a tough one. So now, if you before quote unquote something happens, you want to just make some common sense estate planning moves to protect what you have, so that in the event if something does happen, more of your assets are protected and less are subject to the claims of creditors. By all means, that's fair game, and we'll get into some examples in the presentation today. All right, so just, everybody knows we live in a litigious society. I know where I live. I can't drive down a street without seeing some billboards. I can't watch a television show without seeing some television commercials of "Call me, I'll sue on your behalf. Call me, I'm a fighter. Call me, no cost until you settle. Call me, we fight for you." Same message over and over and over again. It's actually kind of sickening. But and these are a lot of my colleagues, and in some cases friends, sending these messages out over the airwaves and along our highways. So all right, well, good test, Ronald. That worked. Good morning, Roxanne Pennington. All right, and I will tell you, there's a lot of people out there who are kind of subject to lawsuits. You've got the people who get in car wrecks. You've got businesses who are subject to lawsuits. There's an increasing mentality out there of just the public thinking, something happened to me, I'm going to sue somebody. And it's prevalent. I know I've been sued, I don't know how many times over my adult life or over my life, maybe 3 or 4. I remember one time a woman was walking in front of my house on the sidewalk, and she tripped and she broke her arm or her wrist or something. And I wasn't there at the time, but the next day there was the lawyer with the metallic sign on his car door, taking pictures, checking everything out. I got sued. Of course, it went straight to my insurance company and it got resolved, and I didn't have any personal responsibility for that because somebody tripped on my sidewalk in front of my house. I've been sued a couple of times professionally. To me, they were silly lawsuits. They were quickly disposed of, never got to any kind of trial or anything, never even had to settle. They just got dismissed because it was clear that they had no merit. Just in the business that I'm in, sometimes I'll prepare estate planning documents, and then people I don't even know, maybe a child or a grandchild, is upset because they felt like what they got wasn't fair, and so they want to sue me, the lawyer, because they feel like what they got wasn't fair. So that kind of stuff, it gets dismissed. But nonetheless, it's a nuisance at least, and could be a big problem. And everybody has, just about everybody has liability insurance. You have car insurance, you have homeowners insurance. The problem is people can have judgments against them that could exceed the limits of their liability insurance. So let's say somebody has $1 million of liability insurance, they go get in a car wreck, and of course they'll get sued. And let's say someone gets a $3 million judgment against them. The insurance company is going to pay the first $1 million of that, and then that person who successfully sued you could seize your personal assets to the extent of what we'll talk about here in a moment to satisfy the remaining $2 million of that liability. So that's a problem. Or you could get successfully sued for things that you don't have insurance for. Kind of one of the things that comes to my mind is maybe like sexual harassment, environmental issues. So there's a lot of things out there that where lawsuits are filed and you just don't have insurance to cover that type of claim. So the first thing, and maybe another, I'm a little bit getting to be a little bit worried that if you look at the live chat, that both Ron and myself may get sued one day for all of the bad humor that we put on this live chat. I mean, I think neither one of us really should quit our day jobs. But they say, practice makes perfect, and if you do something for long enough, you're going to get pretty good at it. So, Ron, I say let's keep giving it a shot. I don't think either one of us is there yet, but we're getting there. Got to give us an A for effort. Okay, and good morning, Alex. So glad to have you, Alex. Oh, by the way, punch the like button. I know you'll probably tired of me hearing that. So, but it just gives me a little jolt when we get some likes up there and we get some subscriptions, and kind of keeps me motivated. And when it does, tells YouTube to show my videos to more people. All right, so when people kind of freak out, might be too strong of a word, but some people, they call me and they kind of freak out, probably because something happened. And they're like, my son was in a car accident. Can they take my house? And I think some people think that just because an incident occurred, or maybe even just because a lawsuit was filed, that means that very quickly your assets are going to be taken. And that just ain't the case. I'm not a litigator, and so I don't fight these battles in the courtroom every day, but I am a lawyer, and I know enough about the judicial process to know that, an incident may occur, and then at some point, maybe a lawsuit gets filed, because it has to be filed within a certain, typically, number of years because of these statutes of limitations. And then there's a lot of legal maneuvering, and the person who gets sued, they are made aware of this, because lawsuits have to be, the paperwork actually has to be served upon the defendant. So no one can just cram a lawsuit against you down at the courthouse without you even knowing about it. That doesn't happen. But then, lawsuit gets filed. Then there's all the litigation stuff, from the discovery to the requests of the production of documents to the depositions to the, court hearings, the motions, all those things that the litigators do, which take at least months, if not years, for all of that to run its course. And then there's some kind of trial, perhaps, where that ultimately might result in a judgment against you. And then the next step is for that person who successfully sued you to start collecting on that judgment, which is likely to be, many years after an incident occurred, or even many years after a lawsuit was filed. So going back to if you stay awake at night concerned that somebody, you've worked very hard and somebody may take what you've got, then you should take action before something happens. I'm going to quote you a few of our Louisiana rules, because it does say one here, some, and I hate to read the law, but it's necessary. An obligee has a right to annul an act of the obligor, or the result of a failure to act of the obligor made or effected after the right of the obligee arose that causes or increases the obligor's insolvency. So what that says is, when the right of the obligee arose, that means if you get in a car wreck, that's when that right of the obligee arose and you're the obligor. And then any action after that can be annulled or undone. Now, if you took some action before you initiated the car accident, allegedly, of course, then you're okay. But it's not okay. It's this, and I'm not a bankruptcy expert either, but it's, when you do stuff after the fact, there's this, intent to defraud a creditor rule stuff that pops in. So we're really talking about long-range planning, doing common sense things that, just in case you do have a potential liability in the future, you've protected, most of what you have. And we'll talk about what some of those specifics are here in a moment. Okay, let's keep going. you likely own some assets that are exempt from creditor claims. The best example of people owning assets that are exempt from creditor claims is a situation everybody knows about, O.J. Simpson. And O.J. Simpson, he was found not guilty in the criminal court, but then in the civil court where the families sued O.J., he was found liable, and got, I don't remember, maybe a $30 million judgment against O.J. Simpson. But O.J. Simpson has this pension or some kind of retirement from the NFL. And so he was able to keep that. Nobody could take that from him because of the exemption statute. So let me tell you what assets are exempt and what are not. So I'd venture to say many people watching this video, they have an IRA, an individual retirement account. And so all those retirement accounts, and commonly referred to as IRAs, 401ks, 403bs, all of those are out of the reach of your future creditors. So there you have it. We have people who are worried. They come talk to me. Yes, they have a house. It might be worth $200,000, but they had a career at working for a company for a very long time, and they built up their retirement account. It might be $1 million. It might be $3 million. It might be $300,000. And then they also have their checking account and maybe a few other things, but it gives them great comfort to know that retirement account is exempt because that's the bulk of their assets, at least the bulk of their financial resources. Now, we have some relatively new law based on a United States Supreme Court case that many people felt, and probably justifiably so, that when dad died and the children get an inherited IRA, that too would be exempt from the claims of the children, their inherited IRA. Not anymore under our Supreme Court ruling. An inherited IRA is not exempt from the creditors of the person who inherited the IRA. So if dad has a $2 million IRA, he leaves half to child A, half to child B. Each one gets $1 million after dad dies. One of those children gets sued. That inherited IRA could go bye-bye. Now, maybe dad could have said that child's IRA goes into a trust when dad dies. So he named a trust for the child as a beneficiary. Various income tax consequences there, and I've done other videos on accumulation trusts and conduit trusts that are beneficiaries of IRAs. But if you want your IRA that you leave to your beneficiary to be exempt from your beneficiary's creditor claims, you may want to look into some of this. Let's name a trust for that beneficiary as the beneficiary of the IRA instead of it going directly to the child. So that's your retirement account stuff here in Louisiana. A little pittance, $35,000 of equity in the home is exempt. So if somebody gets sued and they get sued, for $1 million and insurance doesn't cover it, and they have a $300,000 home, I presume, based on our law that says $35,000 of equity is exempt, that home would, I guess, get sold, and then the individual would be able to keep $35,000 of that, maybe, and then the rest of it, the other $365,000 would have to be used to satisfy the claim. I want to talk about LLCs for a minute. A lot of people use LLCs that are in business. Most people use LLCs that are in business. So here's a couple of the reasons why. If you go into your business, and if you go into business for yourself as I'll call it sole proprietor. I'm having trouble with that word. Sole proprietor. Then let's say Al opens up Al's lemonade stand, and he's a sole proprietor. And someone walks into the lemonade stand or up to the lemonade stand, and they trip and fall on the sign that says lemonade for 25 cents. Well, Al is going to be personally responsible for whatever those damages are, because that's what happens when you have a sole proprietorship. There is no corporate veil that I'll talk about here in a minute. So the owner of that sole proprietorship is personally responsible for the debts of the proprietorship. That doesn't sound good, and it's not good. So to avoid that, many, I would say probably 90+% of small business owners do business out of an LLC, limited liability company. The idea there, Al forms an LLC and does business as Al's Lemonade Stand, LLC. And now someone walks up to Al's Lemonade Stand and trips and falls and hits their head on the sign that says Al's Lemonade costs 25 cents. Then the proper party to sue would be Al's LLC, not Al. And so the worst thing that could happen is that person who was injured could get a judgment against the LLC, and all of Al's other assets, his home, his savings in the bank, all of that would be protected, his investments. And then there'd be a discussion perhaps about how that injured person who sued Al's LLC could get what's called a charging order and seize any kind of financial interest that Al would have had in that LLC. So bottom line there, if you're starting a business, it just makes sense because it's so easy to do. It's so easy to form an LLC and form and maintain. It's easy to do. And the liability protections can be significant. All right, and then another biggie, and I already mentioned retirement, but in addition to retirement, at least in my state, and again, it's a state-by-state issue, life insurance and annuities are protected most of the time. And I say most of the time because there's a couple of little minor exceptions that I'm not even going to get into. But and when I say life insurance, many people have life insurance that does have cash value. That cash value is exempt. Many people who have annuities, deferred annuities, and they have value there, all of that's exempt. So while some people, while annuities get trashed often for investment purposes, some people who are concerned about, I don't want anybody to take my money, they'll take a portion of what they have and they'll put it in an annuity that's issued by a life insurance company and have the peace of mind that comes from knowing that those assets are protected. We're going to talk in a minute about making donations to trusts. Some people make donations of their assets to their kids to get those assets out of their name. Not the greatest of asset protection tools. Yes, if dad has $1 million asset and he puts that asset into the names of his 4 kids, and dad runs into some trouble in the future and gets successfully sued, yes, that asset is protected. But what if the children get into a car wreck? Now the children own that asset, and what they have is subject to those claims. All right, moving on here. I got to mention here in Louisiana, it's a community property state. So there's this community property, separate property, what's subject to claims. And there's 8 or 9 community property states, starts here in Louisiana, goes west and goes on up the northwest. So Louisiana, Texas, New Mexico, Arizona, California, and others are community property states. If you're not a community property state, you'll have to just kind of check what those rules are in that state. But if one of the married persons has a judgment against them, all of the community property has to be used to satisfy that judgment, and the separate property of the spouse that incurred the obligation is subject to having to be used to satisfy that judgment. So what's protected is the separate property of the spouse who did not incur the obligation. So that often triggers couples who are worried about this kind of thing to do the prenup or to do the postnup, and make sure that there's no community property. Assets are the separate property of either the husband or the wife. It's not the end-all cure-all, because if the husband is the doctor and he's worried about getting sued and he puts assets in his wife's name as her separate property and she goes out and gets in a bad car accident, then the benefit of what they did just isn't there. So those are things. But but we've done a lot of post-nups over the years where, married couple gets young, they're just starting out in their careers, their 20s. Maybe husband or wife starts to get successful, but they're in a career that where there's risk, and so they want to do the post-nup and maybe put a majority of the assets in the name of the spouse who is not most likely at risk. So be aware that that's an obligation. That's an opportunity. All right, now we're going to talk a little bit about how people can use trusts to avoid, to protect assets from claims. Okay, so I'll start out by saying, many people put their assets in a trust for probate avoidance purposes. When they do it primarily for probate avoidance purposes, it's typically the typical revocable living trust. Yesterday was all about revocable versus irrevocable trusts. Assets in a revocable trust are clearly not exempt from claims of creditors for reasons that I'll explain in a minute technically, and then for common sense reasons as well. You shouldn't be able to just put your assets in a trust and have the trust say you do whatever you want to do with those assets, and then that's a magic pill. They're automatically exempt from your responsibilities. So now let's get into what some of those technical rules are. I got to figure most states have something similar. I'm going to go through this where what I'm going to lead up to is that every trust for the benefit of another should be what I call a spendthrift trust, or there should be restraints put on the ability of the beneficiary to alienate their interest in the trust. So it's a mouthful, but this is a rule here in our trust code. A beneficiary may transfer or encumber the whole or any part of his interest unless the trust instrument provides to the contrary. So if you put assets in a trust and say that 20-year-old beneficiary can get the assets when they're 50, if you don't put some kind of restraint on their ability to alienate their interest in the trust, they could go sell that interest in the trust to someone else to get some cash for it because somebody's willing to wait until that person turns 50. So most people who set up trusts for others, they want those beneficiaries to have restraint upon the alienation. So look at our next provision. Our trust instrument may provide that the interest of the beneficiary shall not be subject to voluntarily. Okay, so you can provide, and most people do when they set up a trust for others, that the beneficiary may not voluntarily alienate his interest in the trust. What does that mean? It means he can't, alienate or encumber. He can't sell his interest in the trust. He can't use it as collateral for a loan. It's going to stay in the trust until the trust provision says he can have it. And then there's just a couple of other provisions that are worth noting. This is the seizure. So I'm going to just summarize what that says. So here's the summary. If you put your assets in a trust, and again, emphasis on you putting your assets in a trust, but you retain some right to those trust assets. Maybe you retain the income as the income beneficiary of the trust, or maybe you retain for some reason the right to access some of the principal of the trust. Well, to the extent you put your assets into that trust, then your creditor, let me look at it another way. To the extent someone else puts assets in a trust for you and gives you that right to the income or gives you that right to principal, your creditor can seize those rights. And then if you put your assets in a trust for another, are they protected from that other person's creditor claims? Only if you have drafted the trust as a spendthrift trust. That's why, I get these panic emails or these panic calls years after somebody has had a trust, and they're like, oh my gosh, I've been reading up on trust. Is my trust a spendthrift trust? And I'm like, look at the documents, because just about every trust is a spendthrift trust. The revocable trust thing, that spendthrift trust language doesn't do any good. If you put your assets into a trust and you have the ability to revoke it and put everything back in your name, you're not going to get any benefits of a spendthrift trust. All right. Good morning, Jenny, Lee, and me. And Herbert says, if I form a LLC, which includes my home and farm, which are all the same property, that will help reduce my liability from future suits. It may. It may. Yeah. I could get into a lot of the reasons why, but I'd say, yeah, you've just made it a lot more difficult for a creditor of yours to get your home and farm by putting it in an LLC. Now, here, in Louisiana, you lose your homestead exemption. That's not a big deal to many people. If your home's in an LLC, might cost you $800 or so annually in property tax, additional property tax. That's a loaded question. I'm just going to leave it at perhaps, because I would want to ask you a lot more questions back, want to look at your state law, and kind of go from there. So, but you may, that could be of some benefit. Okay, so there is a provision that says, if you've done some of these things, a trust just isn't going to help you. And which things like if you owe alimony or maintenance of a person whom the beneficiary is obligated to support, or if you have obligations due to necessary services rendered or necessary supplies furnished to the beneficiary or to a person, blah, blah, blah. Damages arising from a felony criminal offense committed by the beneficiary, which results in a conviction or a plea of guilty. Trust ain't going to help you under those circumstances. So, all right. So now with all that being said, let's take just what do people do? So I would say, if there's not a situation has not arisen, you haven't been sued, you didn't go get in the car accident yesterday and it was your fault. You just want some common sense asset protection plans. Yes, you're a hard worker. You're starting to accumulate. You fear that if you continue accumulating and you or your spouse has an obligation, your hard work will be out the window. What do you do? So I would say some of the common sense, easy stuff, max out your retirement accounts. Retirement accounts are exempt. If you own a business, do business as in an LLC or a limited liability company. Don't do business as a sole proprietor. Those are two things right there that are just common sense, kind of no-brainer activities that you should be doing in order to protect yourself and also to accumulate retirement funds for the future, so that maxing out your retirement accounts can have a lot of pluses, not only liability protection, tax reduction, kind of forced savings for retirement. So a lot of good things can come from maxing out those retirement accounts. If you wanted to start taking some additional steps in addition to just the no-brainer stuff, then maybe you inquire about moving some of your cash into an annuity. I'm not crazy about parking cash in a life insurance policy, but some people have done that. Putting some of your assets in a trust for your children, particularly if you're getting into some high net worth stuff, you can not only protect those assets from your creditors and your children's creditors by putting those assets in a spendthrift trust for your children. So in addition to the creditor protection, you'll also be getting estate tax reduction by using those annual exclusion gifts and making gifts into your children's trusts. And that can be done over a period of many, many years, be a gradual shifting of assets that are in your estate, subject to estate tax when you die, subject to lawsuits if you get sued, to out of your estate, reducing the size of your estate for estate tax, and having those assets not subject to either your claims or your children's claims. And then beyond that, there's the crazy stuff, which I really don't get into, the offshore trust, other stuff like that. You may also want to consider, depending upon at what stage of your life, whether you're getting married or you're already married, whether pros and cons of a prenup or marriage contract or separate property agreement, call it whatever you want. If you're about to get married, or even a post-marriage contract, a little more involved in that. I know in our state, you have to get a judge to approve the after marriage or post-nuptial agreement. So a little more involved in the post-nuptial agreement than the prenuptial agreement. All right, so that should start to give you some basics on protecting your assets in case you get sued. Big tomorrow, as I'm winding down, number 15 is going to be about the prevalence of online estate legal documents, what to watch out for, what's the pros and cons, should you, shouldn't you. You know, I've taken a look at a lot of that stuff and have some thoughts that I'm looking forward to sharing with you. If you have any last minute live chat, bring it on in the live chat. And if you haven't already, hit the thumbs up button. Do that for me, please. Also, if you haven't subscribed, subscribe and hit the notification bell. Pleases the YouTube algorithms. We'll see you tomorrow talking about online estate legal documents and number 15 of 20 daily YouTube live master classes in the year 2020. All right, guys, we'll see you tomorrow.